what we did find is that courts do consistently apply something that they call the plain meaning rule. There are a few states, California is notable among them, that follow the approach of the second restatement of contracts, which is a more contextual approach, the kind of, let's call it the Corbin or the more mid-20th century law professor approach. But the majority of courts, the vast majority of courts, apply something that they call a plain meaning rule. And, and basically what we decided was that if the vast majority of courts apply something they call a plain meaning rule, that the restatement needs to have a plain meaning rule. And so that took some time for us to come to that position because we had wanted to originally craft what we thought was a more descriptively accurate rule of what courts were doing. But in the end, we were persuaded by the judges that what we were doing was going to be too complicated and not likely to be followed by courts. And so this may have taken a bit longer than would have been optimal, but we have now crafted a plain meaning rule that we're really very happy about. And there's some nuances there that encourage people to really dig into, but we're unabashedly adopting a plain meaning rule. I would say the biggest nuance that we've addressed is the question of what happens when there's a meaning to a word in a trade. And here I don't mean just the insurance trade, but insurance, especially this, and this is more relevant for the commercial market than for the consumer market. Consumers don't really have special meanings for things. But I may be insuring the trucking industry, I may be insuring the machine parts industry, I may be insuring some industry where they have understandings about what words mean and how things happen in that business. And what we have followed is the New York approach to that circumstance, where the New York courts say, well, the plain meaning rule means the plain meaning as it would be understood by someone who's knowledgeable in the trade. In terms of ambiguity, the real difference that courts have is that what are courts willing to consider in order to determine whether something's ambiguous. And the majority of courts say that you can't consider in determining whether something is ambiguous or not anything that you wouldn't also consider to determine what the plain meaning is. And so, for instance, in New York, which is a state that says when you're looking at what a word means, you're supposed to consider it from the perspective of someone who's knowledgeable of the customs usages of the trade, you can consider that same information in deciding whether something's ambiguous. But what you are not allowed to consider are things that would be course of dealing, prior negotiations, things that are beyond that set of, call them sources of meaning. And that's a term that we use in the comments of it, is we call sort of sources of meaning. And the reason we use the term sources of meaning rather than the term extrinsic evidence is that really courts have different ideas about what they consider to be extrinsic evidence, and that basically people use the term extrinsic evidence for things that they don't want to consider. So, for instance, New York won't call information about custom usage of trade as extrinsic evidence because if it's intrinsic, you can't consider it. And so that's why we talk about sources of meaning, although we do, of course, use the term extrinsic evidence because you can't avoid it.